Right, let's now take a legal perspective on this. We've just had the political face-off between the two former Chief Ministers of Uttarakhand. Geeta Luthra, Senior Advocate of the Supreme Court, will be joining us. Sumit Chandar, Advocate of the Supreme Court, is also joining us. Geeta Luthra, one of the basic contentions against the Uniform Civil Code and the manner in which the BJP governments are going about this is, if it has to be a uniform civil code, it has to be a bill brought in Parliament, it has to be passed by Parliament, it has to apply to every citizen in every nook and corner of this country. Today, if you're going to have states implementing one after another UCC, you're going to have a confusing situation where X number of states will have a uniform civil code and X number of states will not. This process is one that is designed not to have a uniform law across the country.
So, to a large extent, this may be correct. I shouldn't be having necessarily a uniform civil code when I am domiciled, and there is no domicile of a state in that sense. You know, you are all residents of one country, and this issue of necessity of domicile in a place to stand for assembly elections in that state had come up in the Supreme Court, and it said, look, you don't need it because you are ultimately all residents of India now, or citizens of India. Now it's very strange that you will have a UCC in one state and not within the country. So it should be actually a code which should run through the country. Having said that, I must say that there have been legislations particularly pertaining to women's rights, including, say, court fees or other laws. Maharashtra, Kerala have been forerunner in many cases of women Hindu rights and Hindu women rights rather, and they passed muster. So state legislation on a subject like some aspects of, for example, the law with regard to rights of inheritance, rights of co-partnery, all that had come into being in those states, or law with regard to court fees had come into those in certain states. So there can be a progressive legislation state-wise, but this would be an anomaly. You know, it's not a, I think we should have a healthier tradition. And if you are really bringing something as large as a uniform civil code, which in Sarla Mutkal the Supreme Court said was something which was welcome and that the state center should look at, and I think the Law Commission has said so. So it's not that we are not wanting a minimum uniform civil code. I think what we are looking at is, should something as important as a civil code through the country be there for one state and not in the other.
So let me ask Sumit Chandar, you know, the principle of a uniform civil code, particularly when it comes to gender rights, Sumit Chandar, how can you argue for, let's say for example, I'm just using this as an example, a Muslim woman entitled to only 1/4 or 1/8 share of ancestral property, whereas women from other religions are entitled to half, as they should be. They should be entitled as much as the sons get, right? There is inherent discrimination in certain laws which are governed by the personal laws in the case of certain religions. What is the case for retaining those laws? Because it seems common sense that when most, secular democracies around the world, the United States, the UK, other countries around the world can have a common civil code for all its citizens, irrespective of gender, religion, minority status, etc., why shouldn't India?
See, Jacob, it's a very interesting question that you have put in. Now, I do agree, but what you need to keep in mind is that a preamble itself states that we solemnly resolved, and these are the words of the preamble of our country. It clearly states that we solemnly resolved to constitute India into a secular republic. Now, the Indian concept of secularism is based, of course, on the diversity and religion and people. So, there is a huge diversity in our country. This is totally different from the very Western model of law, which is based on uniformity. Now, are we duplicating the Western model of law and forcing to implement the laws in total disregard to the very concept of secularism as enshrined in our very preamble? Now, by doing this, are we not attempting to change the very basic structure of our constitution? Now, Jacob, if you remember, the constitutional bench of 13 judges in Keshavananda Bharati case had ruled by a 7-6 verdict that the parliament could make laws or amend the constitution so long as it does not alter or disregard the basic structure of the constitution. So is UCC going into that direction or not is still a question to be seen, and
No, but
quite possibly
can you
challengeable
explain,
again before the
no,
courts.
can you explain how a law which is clearly discriminatory, in this case, like I said, for example's sake, for argument's sake, I'm saying property rights for Muslim women. It's inherently discriminatory. No one can argue against it. How changing that and making it equal for sons and daughters, how is that changing the basic structure of the Constitution?
Now, the concept of equality is enshrined under Article 14.
Yes, correct.
It's in direct conflict with Article 25, which preserves the freedom to practice and propagate any religion. Now, if you want to bring equality, is the only way to bring about is through a new law or a UCC? Now, whether it is required or same things can be achieved through various amendments in the existing laws. See, there are practical difficulties. It's not that till the UCC was not applicable or brought about, the laws could not provide the reliefs.
Okay.
The very case which is famously talked about, the Shah Bano case, in which what had happened was a 73-year-old woman, Shah Bano, was divorced by her husband using the triple talaq.
Yes.
He said talaq, talaq, talaq 3 times, and accordingly the maintenance was also denied. Now, is it that just because there was a Muslim law inactive, the Supreme Court could not have ruled in her favor or give her the maintenance? No, Supreme Court used Section 125 CRPC, which applies to all the citizens, irrespective of the religion. So, reliefs were being granted even without UCC. And later in 2017, as you are aware, triple talaq was also declared unconstitutional and was removed. So, amendments to the existing laws through the courts,
Okay.
through using the existing laws available.
So your
the same things
contention
can
is
be
you don't
achieved.
need to bring a UCC
Do we
for
really
this,
require
you
a
can
separate
amend
UCC?
existing laws. But Geeta Luthra, the other problem with the
Very
UCC is, one is of course this state by state kind of approach where you may have 10 states adopting UCC and the remaining 20 not. But more than that, even within that, the UCC, even the one in Uttarakhand, is making exemption for tribals, for example. And Uttarakhand is a state that does not have a large proportion of their population as tribals. I think it's less than 1 or 2%. Whereas there are states where the proportion of tribals is very high, Chhattisgarh, the Northeast. How are you going to have a uniform civil code when some of these large sections of population are going to be exempt or going to be out of the ambit of the uniform civil code? Again, there are large sections, traditional customs in the Northeast, in Kerala. There is matrilineal line of succession. Even property division sometimes happens through the mother's side, not necessarily the father's side. How are you going to account for all of that in a uniform civil code?
I believe that the Uniform Civil Code, or what was envisaged as a Uniform Civil Code, was always that you have a core area where you give some equal rights. As you said, rights of inheritance. It's going against the grain of the religious laws where Muslim women get less equal rights. And of course, Article 14 is paramount. But we have tried to preserve a core religious personal law. So the difference is the two aren't clashing. Article 14 assures equality. Article 25 is just trying to keep diversity of personal laws. Now there are some fields where personal laws have been encroached upon, the Hindu Marriage Act being one. After all, Hindus were also allowed to have polygamy, but it is the Hindu Marriage Act which got rid of it and brought monogamy into the picture and into the statute. So, of course, all this has to be progressive, taking Article 14 into account. At the same time, there may be some core religious practices that we can't impinge upon. Can I impinge on the fact that somebody wants to have saptapadi before the sacred fire and invocation before the sacred fire and do the 7 steps as would be done before a pandit? I'm not going to encroach on that. I may have a minimum uniform civil code, but I preserve some aspects of religious law, and that's what there is, unity in diversity. But at the same time, say succession rights, rights of monogamy, all these are being sought to be given because of Article 14 and 15. And that's why this concept of having a core uniform civil code which will take care of these.
So Sumit Chandar, how do you again, how do you argue against having a law that bans polygamy for all religions, a law which says the age of marriage should be the same across all religions, whether you're a Hindu boy or a Muslim boy or a Hindu girl or a Muslim girl, the age, the legal age where you can get married should be the same. It cannot be different just because your religion is different. How do you argue against that? Because that is a progressive law.
Jacob, two aspects to that. One, you are only taking certain provisions and talking about that. It creates a different image altogether. Secondly, why are we only talking about the Hindu law and the Muslim law? There are other laws as well which are going to get affected. The Indian Christian Marriage Act, for example, 1872, has no provision for divorce. The Anand Marriage Act, which is applicable to the Sikh community, has no provision for divorce or adoption. Now, there are other religious or specifically local acts for each community which has provided them with certain laws and also at the same time given certain rights which are otherwise not available to the others. Now, are we, by infringing through UCC, are we going against the very secularism which is given in the preamble of the Constitution? Now, keep in mind, it is not one of the articles in the Constitution. It is the basic structure given in the very preamble, which uses the word secular.
No, but
now the Indian concept of secular.
Can you again? I keep coming back to this. By allowing, let's say, for argument's sake, the Christian Marriage Act and the Anand Marriage Act that you cited, by giving rights, equal rights to Christian women and to Sikh women to divorce their partners in case of the marriage is incompatible, and this is applicable to people across religions. How is that affecting India's secularism? How is that affecting the basic structure of India's constitution? How?
No, so you need to understand again, going back to the what Article 25 speaks about, which preserves the freedom to practice and propagate a religion in the manner they wish to. Over a period of years, this provision or this practice of certain sects and certain religions of the country are being practiced and professed in a certain manner. The Constitution of India allowed them to do so. That is how we remain secular as a country. We remain giving respect to every religion. Sikhs, Christians, Muslims, every religion was given their own freedom to practice in the manner they want.
I think that, so that would be best restricted to religious practices, rituals, etc. I don't think by denying Christian women or Sikh women or even Muslim women for that matter the same divorce and alimony rights as, let's say, Hindu women have, I don't think that's ultra virus of Article 25. I don't think that goes against Article 25 in any way.
Jacob,
unless, of course, the state
intends
intends to trample upon religious practices. Anyway, be that as it may, I have limited time. Thank you very much to both Geeta Luthra and Sumit Chandar. Let's see how this acts through the course of the other states. Already we are hearing word from Rajasthan that they might consider bringing in a bill. Maharashtra is also talking about a bill. But I do agree in principle that a uniform civil code should be uniform across the length and breadth of the country. You cannot have 10 states with a UCC, one version of UCC, and then 10 states not having a UCC, because that's only going to be a recipe for confusion and disaster. So